Ryan, you good? Yeah. All right. Good evening, everyone. I'm going to call to order the State of Rhode Island Coastal Resources Management Council's Rights of Way Subcommittee meeting to order. Today is Tuesday, March 11, 2025. And I set the record reflect the subcommittee members that are present as well as CRMC staff. First matter on our agenda will be approval of the minutes for February 11, 2025. I know they've been disseminated. I would entertain a motion to accept the minutes unless there are any corrections. Motion's been made. Is there a second?
Second.
Motion made and seconded. Any discussion? Hearing none, all in favor say aye.
Aye.
Aye. Anyone opposed? The motion carries. Staff report.
No staff report tonight, Mr. Chair.
All right, I'll bring us right to our matter, Spring Avenue right of way, which is CRMC file number 2020-11-084. And I'm going to turn it over to Attorney DeSesto to handle it for at this point.
I believe all of the legal counsel are present and ready to go. Why don't you all come up? And I don't think it's necessary to identify yourselves. You've been here long. You might want to do that when you first speak. We have two pending motions from the last meeting. But we did get a motion in from the Weekapaug Fire District, a motion to stay. I think it's appropriate to address that one first, if that's acceptable to the subcommittee.
That's your recommendation. It will be.
Mr. Farside.
Thank you. Joe Farside, counsel for the Weekapaug Fire District. The fire district has filed a motion to stay. We filed it last week. And the reason we filed the motion to stay is because we recently received a decision from Judge Raspallo in our Superior Court action, whereby the judge denied the motions to dismiss filed by the Attorney General's office and the town, except for on one grounds, that being the ground of venue. The court in which we filed the complaint was improper according to the judge. So we have since refiled our case in Washington County Superior Court, and the case is going to be reassigned to Judge Raspallo once again. So long story short, the case is going to go forward on the merits. You might ask, well, what were the merits of that case? And in sum, the case is a quiet title action to try and establish as a matter of law that the fire district owns the SAE and should not be subject to the right-of-way process before the subcommittee and the council, and also for declaratory judgment seeking some similar relief regarding the process and regarding the district's ownership of Spring Avenue Extension. Essentially, we're in the lawsuit saying there is enough evidence that we should not be before the subcommittee on issue of whether the Spring Avenue Extension is a right-of-way. The court refused to dismiss the case on substantive grounds, so we will be going forward, and the judge has indicated that we will have a short window to conduct discovery. It sounds like a 3 to 6 month discovery window, but we need to have a conference with the judge in order to set up the time frame for discovery. So with that in mind, we have refiled the case. We are serving the complaint as required by the rules of civil procedure. And our argument now is that there is enough justification for the subcommittee to stay the proceedings here, because we're going to have a duplicative process going before Judge Raspallo. And it would make little sense to the district to litigate both here in this forum whereby the judge will be overseeing parallel issues before him in the Superior Court action. The judge has indicated he's going to move that case along quickly, so asking for a stay doesn't mean that this gets paused forever. It just means that it gets paused while the judge, conducts discovery, oversees the parties conducting discovery, and then has a chance to rule on summary judgment motions. So for those reasons, we've asked in our motion that the subcommittee just stay this proceeding while we proceed in Superior Court as the judge indicated we would.
Thank you. Ms. Boots?
Yes, Randall Boots for the state of Rhode Island, the Rhode Island Attorney General's office. I was under the impression that we were not arguing the motion to stay today, but if we are arguing it, I suppose I can do that. But I just wanted some clarification on whether because we need to object. We haven't filed our objection yet, because it was only filed on Thursday.
Okay, so your main assertion is you need more time to properly respond.
To properly respond, yes, I thought that we were going to be discussing when objections were due for that motion to stay
Correct.
today. And I know that Attorney Farside requested that the additional motions be held in abeyance until that motion to stay was decided. The state of Rhode Island, the Office of the Attorney General believes that that is inappropriate because that would be giving effect to the motion to stay before it was granted. We have prepared to argue the additional motions, and we also believe and will assert in our objection that the stay should not be granted for various reasons. At this point, I can give you guys a few of them if you'd like, or we can put those in our objection up to the subcommittee.
Let's stick to the main issue that you've raised, and that is that you need more time to prepare.
Yeah.
For this, because the motion was filed on Thursday, correct? Last Thursday?
It was.
Okay. Mr. Rubin?
Yeah, I would join with what Ms. Boots from the Attorney General's office has just said. It's Michael Rubin for Caroline Contrada, intervener, and I would join with that. If you want to hear any argument on it, I could wing it, so to speak. So it's up to you, but I would think a reasonable time. Hopefully, I don't mean to impose on the scheduling of the subcommittee, but it would seem that a short period of time would be good if possible, because we certainly don't. If the stay is to be denied, we would want to proceed here at the CRMC, and having an inkling that Mr. Farside will then move the Superior Court for a stay, I would think that the further along we are, the less likely that would be granted. So time is sort of the essence, but we need time to object.
Ms. O'Toole?
Yes, the town would also like more time to respond since it was just filed on Thursday. We didn't receive the motion until the afternoon. Having only 2 working days is really not enough time for us to prepare a substantive motion, a response to Attorney Farside's memorandum. And additionally, I don't see any rush to have the motion to stay done today, because the town's answer in the Superior Court cases isn't due until sometime in April. So I believe we have enough time to try to get a response in and have everything heard here.
So the predicate question for the board is whether or not time should be given to the parties to respond to this motion to stay, given the fact that it was filed on Thursday. Today is Tuesday. That's the first question. I would say that Ms. O'Toole did reach out on the matter to ask about that. And the response that I gave was that that'd be up to the committee to discuss on Tuesday. And if you think it's appropriate for a response, then to set a schedule for the response. And I would add that you know, it is difficult when a motion of this nature comes in And given the amount of work that's been done to date on this matter, you got to expect that there should be some time for a proper response on that. I'd be happy to answer any questions you may have, but that's the decision you need to make.
How long are you looking for?
If that would be acceptable to the subcommittee.
What's your opinion on that?
2 weeks seems, I mean, that's, I'm not gonna say generous, it's kind of the reverse of generous, but, 2 weeks a tight timeline, I think that's pretty good. You're looking at a little less than 3 weeks. And then the matter can be set down so that, the fire district has a chance to take a look at it before your next right-of-way committee hearing, so that they can respond to the objections.
Any questions from our subcommittee for Tony on that one?
I would make the offer that, if there has to be, some sort of, interim meeting, because these meetings are getting scheduled, 2 months apart, essentially. If there has to be an interim meeting, it could be done by teleconference conceivably. Again, I don't want to impose on the committee member's schedule.
Well, let's deal with, do we need a vote on
Yes,
what's the,
the motion would be to allow the other
Oh, yeah.
parties in the matter to have time to respond to the motion for stay, the request being 2 weeks, and then to set the matter down for a hearing at the next available date.
is the subcommittee member is inclined for such a motion?
Should we say the specific 2 weeks?
I think that's appropriate in the motion, yes.
So I'll make a motion to allow the other parties 2 weeks extra time in order to respond to the complaint.
The motion to stay,
The motion to
and
stay,
that would be 2 weeks from today.
and that would be 2 weeks from today.
Second.
Motion made and seconded. Any discussion? Hearing none. Mr. Gagnon,
Yes.
Ms. Reynolds,
Yes,
I too, Raymond Coyer, vote aye.
The next motion should be to reschedule the matter for a hearing, at which meeting, and again, subject to availability.
I'll make the motion that we schedule for a hearing at the next available date of the right-of-way subcommittee meeting.
Is there a second?
we don't need a date certain for that.
Well, I was about to say, how about the second Tuesday in April?
So then, if I may, Mr. Chair, the
Sure.
April meeting of the subcommittee is set for discussion of all other rights of ways that are not named Spring Avenue Extension.
Okay,
How long do you think this motion would take with the objections?
I wouldn't estimate it would require more than 15 to 20 minutes of the subcommittee's time. It's a straightforward motion.
That sound about right for you guys?
Maybe 15 or 20 minutes per side, but. I'm trying to talk quick.
I'd like to know if the
So-
public would have an opportunity.
Not yet.
At that hearing, when you talk about scheduling.
We'll address that later. We've got an issue on the floor now.
Mr. Chair, if I may, if the subcommittee is agreeing with the potential time requirements that each side needs to make, we could have the regularly scheduled subcommittee next month include both this matter and other matters of the subcommittee and extend the meeting to begin either at 4:30 or 5 o'clock, depending on if the room's available.
that's fine.
Can I just consult with the council just for a second?
Could I rise and ask a question? I'm due to speak at the next meeting on April 8th, and I would hope that my petition would come before theirs.
That's fair.
Yeah.
On that particular date, April 8th, I'll be out of state, but Mr. Linus will be here and will be prepared to, represent Ms. Contrada, and that should make it go quicker.
I was about to say, yeah.
But also, I would like to attempt to join by Zoom if possible, but I know that's not always possible. And technology being what it is and so forth. But Mr. Linus will be here in any event.
Okay.
And the final question is, before we have Mr. Palazzolo come up, would the public be allowed to address the motion to stay?
At the next hearing.
Yeah.
Well,
I'm gonna say briefly yes.
if it's.
Why, I don't know, but briefly yes.
That's fine. Okay,
I would suggest we probably stop the meeting at 4 o'clock then, because I think
That's not a bad idea.
additional time.
okay. So
Can you all make it 4?
Yes.
do we have a date?
Yes.
I'm sorry, did you say?
And that is April,
April 8 is the next meeting. We will have the next meeting of the subcommittee, April 8. We will make phone calls first thing in the morning to reserve this room for 4 PM for a 2-hour, maximum 2-hour meeting on that date.
okay, that should leave plenty of time, particularly since Mr. Rubin won't be here, for Mr. Langseth in his matter, and any other things that need to be addressed, and if the public wants to make some comments.
Okay,
I would just, if I can segue briefly into the point that Ms. Boots brought up, which is the need to go forward on the other motions tonight rather than wait, as Ms. Boots indicated, and I think that adds, the fact that I won't be here, I would add more imperative to go ahead with those other motions tonight. Mr. Linus would be prepared to argue the stay motion, but I think that I should be the one to argue the other motions.
Right, we haven't addressed those yet.
Yeah,
This is
okay.
just on the motion to stay.
Yeah, I understand.
Okay.
There's any blocking.
Okay. so I think a motion minutes, we vote on it. I'm sorry, I don't remember if we voted.
Make the motion to.
You made the motion and Trish seconded
Not
it.
voted on.
Okay. So a motion made in,
4 o'clock.
yeah, motion has been made and seconded to continue that aspect of it to the April 8 hearing. That motion was seconded. I'll pull the subcommittee members, Mr. Gagnon,
Aye.
Ms. Reynolds.
Aye.
I too, Ray McCoy, vote aye as it relates to that sub-issue.
Okay, and that's all subject to availability of the room, correct?
Time-wise.
Correct. If this room is not available, we have conference rooms B and C that may be, we will find a spot.
Okay. So the next matter, and I'm going back to the last meeting that we had there. And I for some reason have difficulty pronouncing the name, but it's a motion to quash. Mr. Rubin, that's yours?
Oh,
The motion to quash, I think, was the AG's, the motion to quash the deposition of the Attorney General.
Isn't there 2 motions to quash pending?
there's a motion, I'm not sure if it's characterized as quash, but a motion to strike or the testimony of Susan Carnaccio.
I beg your pardon. Do you mind if we address that one first?
No.
Whose motion is that?
That's my motion.
Okay. Mr. Forsythe.
Thank you. And as I indicated in a brief email over the weekend, I intended to, and I will here, move to ask the subcommittee to hold that motion to strike in abeyance until it can decide our motion to stay. And the reason is because this motion to strike has to do with an approximately 12-volume, 10 to 12-part, very voluminous so-called report that was prepared by an individual named Susan Cornacchia working on behalf of Mr. Rubin, and which contains a large amount of purported evidence related to the Spring Avenue extension. And it's a significant issue in the case of whether or not the materials that she's gathered and put together in all of these volumes should be kept in the case before the subcommittee, or whether Mr. Rubin should be forced to get those documents in through other evidentiary means, as would be the case in a typical proceeding before an administrative body or a court. In other words, our position in some, and I have detail to go into, but I'm going to refrain for the moment, is that this information is improperly before the subcommittee and improperly proffered in the case and should be stricken from the record. Because it's so voluminous, it's important to decide whether or not that information will stay in, or in fairness to Mr. Rubin, whether he'll have to pursue other avenues to have those documents and evidence admitted in the case before the subcommittee. So it makes very little sense to us for the subcommittee to hear that motion tonight and rule on it when we file the motion to stay and we believe we satisfy and will satisfy the elements of the legal standard for the motion to stay, and where that motion to stay can be heard on April 8th, not prejudicing anybody if we wait to rule on this motion to strike until after a decision is rendered on the motion to stay. So for that reason, it seems premature to rule on this motion to strike today or shortly after today when we have this motion to stay.
But there's a practical problem, if I may, and that is, I'm fine with, Sean, substituting for me on the 8th. That motion is going to be objected to by all three proponents. In other words, the Attorney General, Caroline Contrada, and the town. This one is really up to Caroline Contrada to defend because it's essentially her witness. I'm basically the one that's prepared for that. And I'm basically flying solo on that one. And I'm the one who's already invested the time in preparing for it twice now, actually. And actually 3 times, as I'll explain in a moment. And so as a practical matter, if there would be prejudice to Caroline Contrada if the motion to stay was denied and then it had to be pushed back yet another month or maybe even 2 months for this objection to be cleared up. And let me tell you where I'm coming from in terms of mentioning 3 times. The 3 times comes from the fact that this motion has already been made and conditionally denied. In other words, it was deferred until hearing, which is essentially, for the interim period of denial. Then it was made again when it came prepared last time. Mr. Forsythe was able to be present, understood, and was set to argue it tonight. Now, if we're going to have it on April 8th at night, I can't be here. That's going to create a difference. I would just add, looking ahead at the merits of the motion to stay, I don't see this council abdicating its responsibility on rights of way. We're not talking about the underlying fee title. And Mr. Forsythe makes a lot of references to ownership, meaning the underlying fee title. We're just talking about an easement right of way. So I don't mean to argue that in advance, but I think there's a lack of likelihood that would be successful, at least in this form.
And my reply to that would be twofold. One, Mr. Rubin's availability on the 8th should not drive the decisions of the subcommittee. And secondly, our lawsuit does a lot more than call into question or attempt to resolve the issue of ownership. It also seeks an order declaring that the CRMC no longer has authority to continue with the referral of the SAE as a right-of-way, and seeks judgment in favor of the district in that regard. So I don't want the lawsuit to be minimized in terms of what it seeks to accomplish.
If I may, just because we're talking about whether or not to hold a motion in abeyance. I do think that, we have decided that we were going to, argue these motions tonight. The subcommittee was prepared to hear them. I know Attorney Rubin, cut short a previous commitment that he had in order to accommodate Attorney Farside's, calendar, because he could not be here on the 25th. I think in fairness, the parties should be permitted to argue these motions that they have come prepared to argue twice. I also think it does move the matter along, and by holding it in abeyance, could be interpreted as giving Attorney Farside's motion to stay effect before you have actually granted it. And for those reasons, I would ask that the subcommittee not hold these motions in abeyance and hear them tonight.
The only thing that I would like to add is if Attorney Rubin is ready and willing to go forward on this motion, I don't see there being any prejudice to the fire district if a decision is made on this particular motion. So I think it should go forward if the attorneys are ready.
May I ask a question? What's the substantive objection? Relevance?
The substantive objection is that it does not qualify as an expert report under Rhode Island law, and it got a lot of details to explain why that is.
I understand, but I have a question. Is this being offered as an expert opinion? Like an expert report?
There's two alternative theories, of course. Because, you know, experts will often testify to lay facts, well, as in the course of their testimony. But I do believe that it qualifies as expert reports by a researcher or an archivist. Notwithstanding that, and what I'm hearing Mr. Farside say is he wants to disqualify them altogether, and lay witnesses are allowed to prepare summaries of their lay observations. So even if she was disqualified as an expert, it wouldn't eliminate the introduction of this evidence. There might have to be some redactions as to some conclusory comments. But it would seem to me that these reports could come in as lay summaries. I don't have the rule to cite, I think it's 711, I'm not sure, to cite for you off the top of my head. And there's also that lay witnesses are allowed some leeway on some opinion matters. So, you know, this clear, bright line isn't clear, and I'm not sure exactly what Mr. Farside's asking for, because the motion seems to be characterized as a motion to eliminate her as an expert. And now I'm hearing tonight that the report shouldn't come in at all under any.
The motion is, as it's titled, to strike her expert reports, exclude those materials from evidence. Very clear.
The entire report?
Yes.
And based on the fact that it's as styled as an expert report?
Based on the fact that her proffered expertise is in archival, and nothing that she did has anything to do with how you archive things or where to go find things, or addresses a problem in this case that's presented by an inability to find things. It's all lay summary of paperwork that she obtained from an infinite number of sources. I'm not saying it wasn't a lot of work. It was clearly a lot of work. But it's not to do with what the expertise of an archivist should bring to this matter. And again, I have more points to make on this. I'm not diving into my argument right at this moment while we discuss the issue of whether to hold the motion in abeyance, but I'm happy to kind of go through in detail why her expert report should be stricken.
So the first question is whether or not this motion should also be held similar to the motion for the stay. On this, you've heard the arguments on both sides. We can get into the merits if you decide that it should go forward.
What's your recommendation based on the arguments?
You have, these court cases going on, but I've noticed that there's no, stay issued by the Superior Court at any time, and I understand it's preliminary because it was a dismissal on procedural grounds and going forward. But absent any action from the Superior Court, staying, the matters, I don't see why you wouldn't want to go forward on these things. And, we can get to the merits in a second, but I do think they should be addressed to move these matters along. It's been going on for some time. And it's holding up, other matters that you have. So I think they should be addressed as quickly as possible. If the Superior Court sees things differently, we'll hear from them and then we'll act accordingly because they do have ultimate jurisdiction, if that's the case. But this is still a administrative matter, and I'm sure that's an issue that's going to be litigated in Superior Court too. So to me, advising you as your lawyer, I think they can go forward and hear the merits.
Okay. Do you need a motion to that effect?
Yes. The motion would be to deny the request to stay the hearing on this motion.
Based on your recommendation?
Correct, yes.
The subcommittee accepts that recommendation. Is the subcommittee members in a posture to make a motion?
I'll make a motion to deny the request for the stay on this motion.
Is there a second?
Attorney advice.
Second.
What's been made and seconded? I'll pull the council, Mr. Gagnon.
Aye.
Ms. Reynolds?
Aye.
I too, Raymond McCoy, vote aye.
Okay, this is Mr. Farsight's motion. He can get to the merits.
Thank you all.
Yes.
As previewed, this relates to extensive so-called expert work of Ms. Susan Cornacchia. She is a self-described archivist. In other words, she's a gatherer of documents that she intended would be used by others. She's not herself an independent expert witness in this matter, and I'll explain why. She admitted that much in her own deposition, which took place last spring. She stated in her deposition at page 43, and I quote, that she was gathering the materials that have to go before the proper experts to make the decision. Anything that I have assembled, I expect would be reviewed by people with other expertise. And I can't claim to understand the legal theories that come into play. She also admitted in her deposition at page 29 that she did not have any formal education or credentials in land surveyance, matters of title, land evidence records, aerial photography, or cartography, all of which are the main areas of expertise that are at issue in the matter of whether Spring Avenue Extension was ever used or dedicated as a public right-of-way. But now that Ms. Cornacchia has compiled binders of documents, it would be convenient for Ms. Contrada's counsel to just have those binders accepted as an expert report and reviewed as evidence by the subcommittee. That would save him the work of laying the foundation needed to authenticate lots of documents that came from lots of different sources. That's what's typically required to have documents admitted. In other words, he's looking to have Ms. Cornacchia's work be used as a fulcrum or a shoehorn to get binders and binders of documents that she's located into evidence in this case under the pretense that they are, quote, expert reports. But they are not examinations by an independent, unbiased person with the expertise of an issue or hypothetical related to the Spring Avenue Extension matter. An expert witness is supposed to be able to help the trier of fact, in this case, the subcommittee, answer a question that's difficult from a technological standpoint or from a scientific standpoint, something on which the committee doesn't have the proper technical expertise. Instead, these are just compilations of documents or even portions of documents pulled from a variety of public sources. In addition, they're not even just the documents themselves so that the subcommittee can examine them and make its own conclusions. Almost every single one of these documents contains Ms. Cornacchia's own annotations, musings, labels, comments, captions, markings, highlighting, other coloring, arrows, thoughts, and lots of conclusions, all of which thoroughly pollute the substance of the actual documents. It's not as if there are documents that are just existing in their native format for you to read and think about. These documents have highlighting mixed in. They're color-coded in a variety of ways. They have paragraphs upon paragraphs of Ms. Cornacchia's thoughts about what the document says. Well, that's not what an archivist does. An archivist is somebody who knows how and where to find things. And if there was an issue in this case about how and where to find things, then an archivist might be a relevant expert. But here the archivist is being used to compile documents that tell a narrative that's convenient to Mr. Rubin's case, and he wants to put all that before you in order for you to then have a nice, convenient package of his narrative without him having to lay the foundation for all of these documents. Ms. Cornacchia is also extremely biased, a characteristic unbecoming of an expert, a true expert. She's called Westerly Fire District's non-firefighting. She's referred to the leadership of one Westerly Fire District, the Shelter Harbor Fire District, as a, quote, crime family. She's accused all fire districts of being, quote, private peninsulas that are perfect for nurturing white-collar crime. She's claimed that Westerly, of all places, who's here fighting about this right-of-way, has a, quote, long, shameful history as the biggest threat to shoreline rights, confirming that Ms. Cornacchia is on the side of shoreline activists, not an impartial expert. She's advertised on her social media a plane flying a banner stating that the Rhode Island shore is not private, which is certainly her prerogative, but disqualifies her from serving as an impartial expert in this matter of any kind. She's also accused the Watch Hill Fire District of showing, quote, how public ROWs are stolen, end quote. Letting Ms. Cornacchia's so-called expert materials remain in this case would be tantamount to saying that an archivist could be used in every single case, whether administrative or judicial, to shoehorn in documents that are beneficial and have not only help a case in the opinion of its lawyer, but have lots of text and highlighting and markings that pollute those documents. It would end run the rules of evidence and the rules applicable to expert witnesses, and such an absurd result cannot stand and shouldn't be tolerated here either. The rules of evidence lay the standard for expert testimony. It must be 1, provided by someone qualified in their field. 2, based on authenticated documents and information. And 3, provided from an impartial and professional perspective. Number 1, qualified in her field. Her field is archival. Again, nothing she's presented here has anything to do with archival. For example, how or where the record was kept or what efforts were needed to be undertaken to find the same. Instead, she analyzes, reviews, or comments upon land evidence records, surveys, plat maps, and other documents that require other experts, as she herself admitted. She's simply not opining on matters of archival. Number 2, her so-called opinions are not based on authenticated documents. An expert generally cannot form an opinion on documents that would otherwise not be admissible in proceeding. Otherwise, the rule requiring authentication of evidence would be deemed irrelevant. Rule 703 of the Rules of Evidence explicitly states that the expert's documents must be, quote, in evidence. For all the reasons I've already stated, we don't have an expert report based on documents in evidence. They're not in evidence. 3, Ms. Cornacchia is biased and not impartial. The Rhode Island Supreme Court has said that one cannot be vehemently opposed to something and serve as an expert in an administrative matter against that issue. That's exactly what would happen here. She's vehemently opposed to fire districts. She's opposed to anything other than shoreline access or an increased improvement of the same, or an increased amount of access, I should say. And she cannot serve as an expert in this administrative matter due to her bias. Her bias shows through in the many narratives she's created in connection with the documents she's proffered. Cornacchia has admitted in her deposition that her work was intended for use by other experts. Her work was not intended to serve as a standalone expert report that would be able to be used in this proceeding. Finally, to the extent that Ms. Contrada, Mr. Rubin's client, had claimed in her objection to the original motion that this is a matter of conventional admissibility issues, this motion is exactly meant to avoid those issues and streamline the matter for the final hearing on the merits. In other words, we don't want to get to a final hearing where the issue of these voluminous binders of material hasn't been decided. We want to know, and frankly, it's fair to Mr. Rubin to know, that if he's got to get documents admitted before this subcommittee, he needs to do so appropriately and not through shoehorning through a voluminous amount of expert material, so-called expert material from his archivist. I appreciate your indulging my argument, and I'll now cede the floor to Mr. Rubin. Unless you have questions. for me.
Any questions from Attorney Farside at this point? No?
If I may just go to my, my briefcase. I didn't want to get up and distract while Mr. Forsythe is speaking. But, I think this is all very, very abstract. Let's get down to brass tacks. What we have here, and I'm sorry I couldn't get it printed. I did mean to have it printed. Is the report that was done by, excuse me, I just closed out of it, by their expert, their rustologist, if you will, which is their witness that's a material scientist, a metallurgist. And that expert rendered the report I'm about to show you. I'm sorry I didn't have a chance to get it printed out. Actually, that was Staples' fault.
Our metallurgist report is not an issue for the subcommittee today.
I think the idea of being marked upon was the central point that Mr. Forsythe made. And if I can approach, I can show you.
Before you do, Mr. Rubin, is the report can be offered as an expert report?
You know, the reports of Ms. Cornacchia will be offered both as expert reports and as lay summaries. And her testimony will be offered in a like manner. I think we're getting bogged down in semantics here, because if a person goes to an archive and looks up something, they can come and testify. And they can say, this is what I saw, this is what I found. That's lay witness testimony. Now, I do believe that one of the tests that Mr. Forsythe referred to is authentication. And one of the things about authentication is, was it kept in a natural and regular place of custody? Who better than an experienced archivist to testify that this document found in this archive or found in this collection or found in this branch of the Library of Congress is kept in a regular place of custody? That is a subsidiary issue upon which Ms. Cornacchia can bring expertise. And so, I'm allowing myself some elasticity here, and this is why I think the council had wisdom in deferring this issue to the hearing, because whether if a person goes and they go to an archive and they say, this is what I found, that is lay testimony, and that doesn't require any expertise. Now, is there some expertise in determining whether that archive is a regular place of custody? Yes, as a subsidiary issue. So I think that there is like a mixture of lay issues and expert issues. And Mr. Forsythe, seems to want to knock out all of these reports and her testimony based on all of these reports and her ability to introduce these items into evidence. But his argument is all based on whether or not she's an expert. But whether or not she's an expert, somebody can come in and say, I went to this archive and here's the photograph that I found.
Can I ask a question?
Yes, yeah, right ahead, yeah.
Are we anticipating Ms. Kanacha to come in and testify at some
Yes.
point?
Yes, absolutely. That's why, and that's why this motion has been made, is to stop her. And it seems to want to stop her both as a lay witness and as an expert witness. And I'm saying that.
Isn't that something that we can let the documents in and then afford them their due weight? And when they're laying on the table there, they make the argument, this is an expert, this is a lay, this comes in, this doesn't, where'd you find it? Who wrote this on it? I mean, it seems like we have to have them in front of us.
Yeah, under Rule 702 of the Rhode Island Rules of Evidence, for someone to testify as an expert, they have to be qualified as an expert.
Right.
That's the first thing. The second thing is this report can come in and you give it the weight that it is entitled to. I'm not entirely clear as to what the expertise is here. And it seems like Mr. Rubin is already on his fallback position, opinion testimony by lay witnesses under Rule 701 of the Rhode Island Rules of Evidence. And that may be the case.
Yep.
But I'm gonna say it's great arguments. But in this instance, because this is premature, because when you get to hearing, these are gonna be issues.
Yeah.
Is the witness an expert? Is the report an expert report? That's something you're gonna have to see and you're gonna have to argue on. But to me, you can't make that determination now without seeing them and also hearing what the qualifications are. So at this point, I think what you need to do is deny the motion and because it's not ripe, and let this play out when Ms. Cornacchia comes in. Take a look at the report. See, is this an expert report or is it just somebody that went out and took a look, in the land evidence records and started compiling things, as Mr. Farside said. She's not at that point yet. Is she an expert or not? Well, that's gonna come out when she gets to the stand. So at this point,
That's exactly where I'm inclined. I mean, I'm listening to your argument and I get it, but I think they're gonna end up here and the arguments are gonna happen at another hearing anyways, when the documents are in front of us. And that's where you have an opportunity in front of us to attack her credibility, her expertise, the writing on the document or that, but at this point, for me to make a decision based solely on a legal argument and a summation of quotes and that, I'm not comfortable doing that myself. I don't know what my fellow members.
If I may respond, the point here is she's been offered as an expert. Mr. Rubin might like his fallback argument that she could be a lay witness and he could try to put her on and we'll object at that time. I can't stop him from trying to put a lay witness on to testify about A, B, or C. My point is we can have an argument today and a decision today about whether she's an expert. And there's so much evidence here that she's not one, that he should be limited to trying to introduce her as a lay witness. And I don't think he can do that either, but that's not what you're arguing today. He's put her forth as an expert and that's what we have a problem with.
okay, but she hasn't been accepted as an expert.
Yeah, that's what I'm saying. I mean, he can put forth anyone as an expert, but we haven't accepted them as that yet. So that's gonna happen that night. I'll say, I call Susan Kanacha, what's your area of expertise? Bang, that's when you can attack it. And that's when we make that decision. Yeah.
By denying the motion tonight, you're not accepting Ms. Cornacchia as an expert. That's something that would take place at a later time when you have the report in front of you.
Exactly.
When you can hear what, if any, qualification she has.
And we've done that many times. We've done it in
Yes.
courts and I want to, again, I'm speaking for myself personally. You guys can opinion on it, but I want to make that decision that night when I hear all the arguments and credentials and that. So that's where I'm leaning.
I think I would tend to agree, my limited experience in being an expert witness, you have to provide a resume and qualifications and right before you testify and you decided before you get up on the stand if you're an expert or not. We haven't even seen any, like a resume or any information about this person or their qualifications or where they're coming from, so I would agree with Chair Coyer. We don't have the information yet to make that decision.
I also agree on that.
The resume has been submitted as, part of discovery, and it's a quite extensive resume of a person who has a master's in library science. But I don't want to belabor this. I understand once a judge indicates where he's going, you sit down and shut up. Nonetheless.
But you're not doing it, Mike.
Versions have been made about marking of exhibits, and I have to take exception to that because that's exactly what their expert did. They put arrows on an exhibit. It's an innocent thing.
But I
Hold
don't
on,
need to see
hold
that.
on. Yeah, we haven't,
Did I miss something? Let me just, because if I misstated something, I want to be staying corrected. Attorney Foster, did you not say in your argument that she admitted that she wrote and summarized things on the documents that
She did that throughout.
Okay,
And my point was, she's not qualified as an archivist to annotate documents across all these different, the spectrum
Okay.
of sources she
yeah,
found.
I just wanted to make sure I understood it correctly, so.
Yeah, our expert wrote stuff down too, but they were qualified to write what they wrote.
So we have before us a motion to strike,
correct, yes.
and denying the motion to strike would allow it just to us to hear it at another time, or?
Correct, yes.
I would just ask.
It's not a motion to strike. What would, well,
What's a motion to strike the report in her expert materials, I thought. Isn't that what's,
I would ask that it be denied without prejudice.
yeah, that's actually appropriate.
okay,
If I might add, that's what the committee already did. You already heard this motion several months ago, and that's what the decision was at that time.
all right. Someone in a posture to make that motion, please?
I would move that we deny the motion without prejudice.
Correct.
Is there a second?
Second,
Motion made and seconded. Any discussion? Hearing none, Mr. Gagnon? Ms. Reynolds?
Aye.
I too, Ray McCoy, vote aye. What's next?
Thank you very much.
Thank you.
Now, the next motion is from the Attorney General to quash. Ms. Boots.
Yeah.
Wait, hold
Again,
on.
Randall Boots for the Attorney General. So the motion to quash, I am happy to argue that today at our last hearing on this. However, the subcommittee did want to wait until the APRA litigation that the fire district brought against the Attorney General's office had a decision. It does not yet have a decision. So I wanted to lay that out for the subcommittee before we made arguments.
Judge Rospallo indicated we might have a decision this month.
Oh, okay, I beg your pardon. I had thought that the case was dismissed.
Different case.
That was the other case,
Yeah.
sorry.
There are quite a few cases here.
Is there an objection to having it continued?
No.
Why don't we set that down for the next meeting also? Judge Ross follows prompt in his judgment and his
Yes.
decisions.
And what is the motion to quash what, please?
The district's motion to depose a representative of the AG's office. So will that be at the April 8th
Yes,
subcommittee hearing? Yes, okay, great.
I think that's it.
Need a motion to continue?
Motion to continue to the date as set forth.
Entertain that motion, please.
I'll make a motion to continue with this to the same April date.
Is there a second?
Second,
Motion made in second. Any discussion? Hearing none. Mr. Gagnon?
aye.
Ms. Reynolds?
Aye.
I too very require vote aye. So that'll be continued to the April 8th. Okay,
Thank you. That concludes the matters on for this hearing.
Thank you all.
Thank you very much.
guys.
Thank you.
All right, entertain a motion to adjourn. Seconded. All in favor, say aye.
Aye.
Meeting adjourned. Thank you.